Following the principles discussed in the previous section on the handling of earnest money for unimproved lots, it is equally critical for licensees to understand the disclosure and procedural requirements when earnest money is made payable directly to a seller rather than held in escrow. Arizona law establishes clear standards governing these situations to prevent misappropriation, protect buyers from financial risk, and ensure compliance with the Arizona Revised Statutes, ARS, and the Arizona Administrative Code, AAC. Specifically, ARS Section 32-2-151A and Commissioner's Rule R4-2 8-802C require that any agreement in which earnest money is to be delivered directly to a seller or any person other than a licensed escrow company must include full written disclosure and the buyer's informed consent before the funds are released. Direct-to-seller earnest money transactions are most commonly found in land sales, private transactions, or situations involving small developers who do not maintain a traditional escrow process. While such arrangements are not prohibited under Arizona law, they require careful documentation and heightened diligence by the licensee to ensure that all parties are fully aware of where the funds are being held, who is controlling them, and under what conditions they may be released or refunded. The licensee's duty under R4-28-1101A to protect the public and act with honesty, fairness, and competency remains paramount in these cases. The contract itself must clearly specify the name of the person or entity receiving the earnest money, the exact conditions under which the funds will be held, applied, or forfeited, that the funds will not be held in escrow and may not be subject to the same protections as escrowed funds, that the buyer understands and agrees to the arrangement. For example, if a seller of an unimproved lot in Cochise County asks that the earnest money be made payable directly to them, the licensee must insert a clause in the purchase agreement disclosing that the funds will not be held in escrow. The clause must also indicate that because the seller will personally hold the funds, they will not be protected by escrow law, and any disputes over their disbursement may require civil resolution. If this disclosure is omitted and the seller later refuses to refund the deposit after a failed transaction, both the broker and licensee could face disciplinary action under ARS Section 32-2153 for negligent conduct or failure to disclose a material fact. In accordance with ARS Section 322.151.01c, brokers are required to maintain a complete record of all earnest money deposits, even if those funds are not handled through the brokerage's trust account. This includes copies of checks, wire transfer receipts, or written documentation verifying the transfer of funds to the seller. The designated broker is responsible for ensuring that each file includes a written acknowledgement signed by the buyer confirming that they were informed of the non-escrow nature of the deposit. Example scenario: a buyer agrees to purchase an undeveloped parcel directly from a private owner for $85,000. The seller requests a $3,000 earnest deposit payable to them personally, stating that they will use it to cover survey expenses. The buyer's agent, unaware of the disclosure requirement, allows the payment to be made without written consent or explanation in the contract. The deal later collapses when the buyer's financing falls through and the seller refuses to return the deposit. The buyer files a complaint with the Arizona Department of Real Estate, ADRE, alleging that they were misled about the handling of the funds. The ADRE investigation determines that the licensee violated R4-28-802C for failing to ensure proper disclosure and R4-28-1101I for failing to exercise reasonable care. The broker and agent face administrative sanctions, and the buyer must pursue civil action to recover the funds. The rules governing direct-to-seller earnest money are grounded in Arizona's strong consumer protection principles. Courts and the ADRE have consistently emphasized the importance of transparency and written consent in such cases. In ADREV, Adams Realty Group, 2017, the department reaffirmed that the failure to disclose non-escrow earnest money handling constituted unprofessional conduct and violated the broker's fiduciary responsibility to ensure compliance with all statutory safeguards. To mitigate risk, the best practice for licensees is to encourage the use of licensed escrow or title companies for all earnest money deposits. When a direct-to-seller arrangement is unavoidable, the licensee must ensure that the purchase contract and any addenda clearly outline the terms of handling, refundability, and potential risks associated with the arrangement. Review summary. Direct-to-seller earnest money requires complete transparency, buyer consent, and written disclosure within the contract. The licensee must confirm that the buyer understands the funds will not be protected by Arizona's escrow statutes and that disputes may not fall under the purview of ADRE. The broker must maintain documentation of the buyer's acknowledgement and ensure that funds are handled according to contract terms. Compliance with ARS, Section 32-2151. ARS, Section 32-2151.01 and AACR 4-28-802C ensures accountability, prevents misrepresentation, and upholds the licensee's duty of honesty and fairness in every transaction. Discussion prompts. Why does Arizona law require written disclosure for direct-to-seller earnest money arrangements? Answer. To ensure the buyer understands that their deposit is not protected under escrow law, and to safeguard against potential misuse or disputes. What should a broker include in the transaction file when earnest money is paid directly to the seller? Answer. A copy of the buyer's acknowledgement, proof of payment, and a clear statement in the contract detailing how the funds are handled. What is the best practice for a licensee when a seller requests direct payment of earnest money? Answer. Encourage the use of escrow whenever possible. If not feasible, document full disclosure and obtain the buyer's written consent before transferring funds. Closing remarks. Proper handling of earnest money is one of the most critical elements of ethical and legal compliance in Arizona real estate. When funds are made payable directly to a seller, the stakes are even higher. Full disclosure, written consent, and precise record keeping protect not only the client's interests, but also the licensee's professional standing. Upholding these standards reflects a broker's and agent's commitment to integrity, transparency, and the public trust that defines Arizona's real estate profession.